Hi, welcome to another episode from our GDPR IQ Thought Leadership series. Here we'll be discussing the obligation on financial firms to appoint a data protection officer. The finance industry is accustomed to strict regulations and oversight, but with the implementation of the GDPR, financial service organizations are required to tighten their policies and procedures around the usage and storage of personal data. GDPR significantly impacts any organization that processes EU citizens' data, even if the business isn't located in the EU. Data protection breaches are regularly making headlines, and privacy has taken center stage. Ramifications for financial services organizations like banks and investment advisory firms are far-reaching, up to 4% of annual global turnover. The GDPR states that a data protection officer is a linchpin and plays a key role in ensuring compliance with the GDPR. They are the first point of contact for data protection queries, working directly with the C-suite, and act as the liaison between the organization and the supervisory authority, such as the Information Commissioner's Office, or ICO in the UK. The data protection officer needs to be the internal authority on data guidance, an expert on all things GDPR. The DPO must be independent to avoid any conflict of interest. The concept of appointing a data protection officer, or DPO, is not new. It has been best practice and mandatory in some countries. However, the GDPR has made the appointment of a data protection officer mandatory in some circumstances. Financial service organizations are likely to be caught here. Whether you're a controller or a processor, if you're processing large amounts of personal data or special categories of data, or processing data on a large scale, particularly sensitive data. A DPO is not required if personal information is not processed by your organization, or personal data is processed but on a small scale. Even if a DPO is not necessary, you should keep records of any data breaches and your decision-making process. The GDPR applies to businesses offering goods and services, and to controllers and processors that process personal data of individuals in the EU, regardless of where the organization is established in the world. If your financial firm is not established in the EU, you are required to appoint a representative who is to achieve GDPR compliance. The GDPR requires the DPO to be appointed on the basis of professional qualities, and in particular, expert knowledge of data protection law and practices. The DPO should be involved in all data protection issues as early as possible, and their focus should be on monitoring compliance. Their duties include advising the organization and employees with obligations to comply with the GDPR, assisting with monitoring internal compliance, raising awareness of data protection issues, training staff, conducting internal audits, monitoring and providing advice, data protection impact assessments, or DPIAs, and to act as a contact point for cooperating with the supervisory authority and data subjects. The data protection officer is not personally responsible for non-compliance with the GDPR. The liability is with the controller or processor to demonstrate that the processing activities are in line with the GDPR. If an organization decides against following their DPO's advice, they should record their decision-making to demonstrate accountability. Although a financial services firm can promote a member of staff to the role of DPO, it's strongly recommended to appoint a DPO with expertise on the GDPR. Thanks for watching the GDPR for Financial Services video. Subscribe to our channel for more on how to tackle the EU GDPR, and feel free to watch more videos from our GDPR IQ series here. Don't forget to check out our website or follow us on our social channels. Thanks again, and looking forward to seeing you.